Welcome to the Canadian Condominium Institute CCI podcast, brought to you by the Grand River Chapter. I'm your host, Michelle Dyer. We took this episode of the podcast on the road for a very important topic, navigating bad behavior and mental health in condominiums. Please note that during this episode, we share real-life experiences, and the scenarios and situations described may be sensitive to some listeners. So just be aware that discretion may be needed. Welcome to the CCI Grand River Chapter Lunch and Learn, Navigating Bad Behavior and Mental Health in Condominiums. My name is Michelle Dyer, and I'm from the superb group and host of the CCI Grand River podcast. Thank you for taking the time out of your busy schedules to join us today. I'd like to now draw your attention to our panelists today. The topic, again, navigating bad behavior and mental health in condominiums, and I'm going to call upon our panelists to introduce themselves and tell us a little bit about themselves. Go ahead, Chris.
I wasn't expecting that, but thanks, Michelle.
On the fly, Mendes, on the fly.
Hi, everybody. My name is Chris, and I am a condominium lawyer at SV Law, and I'll be talking today about some of the legal frameworks when discussing mental health and condo obligations, and hopefully give everyone a very high-level overview of the process and before we get into sort of an individualized discussion.
I'm Bill Thompson. I'm a retired property manager, court-appointed administrator, owned my own property management company for about 35 years. I'm here basically to give practical information.
Hi everyone, my name is Iman Grewal. I'm with the Canadian Mental Health Association, Waterloo, Wellington chapter. I'm a mental health educator and an advocate in the community as well. I'm also a Safe Talk trainer, which is a community suicide alert program that we also deliver to anybody that's interested. We can chat about that afterwards. Also a meditation and yoga practitioner, 4th generation. And so just here to lend some mental health advice, resources, education, discussion, any way I can help, anything, yeah.
Let's talk to the lawyer, Chris Mendes. He's going to give us the legal framework.
Hi, everybody. Thank you, Michelle. So we're here today to talk about bad behavior and mental health. Now, there is a difference, and it's a very sensitive topic, one that which probably touches 100% of everyone here today. So, of course, the goal is to talk about these issues, get a discussion going, and to do so in sort of a sensitive manner, but also in line with what, condominiums' legal obligations are. And if there are property managers here and board members, probably things you address on a daily basis, if not multiple times a day. But so my goal for the initial part of this presentation is to give you sort of a very broad overview of the legal framework on how we deal with some of these things before we get into sort of a more discussion-based approach where we're going to go through some scenarios and get some people's opinions on how to deal with it. They did give me a clicker. I gave it to Bill because I'm awful at technology, surprisingly. So, thank you, Bill. So the first thing I wanted to talk about is the Human Rights Code. So the Human Rights Code is a piece of legislation in Ontario that prevents discrimination against people from organizations or from other people on a broad spectrum of categories. So it includes physical disability, but also mental disability. So it's important to know that a mental disability or a mental disorder or mental illness is an enumerated grounds for discrimination in the Human Rights Code. And when dealing with a Human Rights Code issue, condominiums as an accommodation provider, and by accommodation in that sense I mean housing, although you don't own the units, you are responsible for managing and administering the common elements and property in general. And that includes dealing with issues that may arise under the Human Rights Code or where somebody needs an accommodation under the code. Now, the Human Rights Code supersedes all other legislation in the province, and that includes the Condominium Act. So where you would see something like this come up, the most common, I would think, are accessibility parking, but also service animals. How many people have a condominium that prohibits pets but receive requests for a dog despite that? Just a show of hands. So I'm saying probably 50% of the people here have received those kind of requests. So what are you supposed to do? What does the Human Rights Code say when you get these kind of requests? So let's say you have a declaration. Your declaration prohibits all animals in the condominium, but someone says, no, I need a support animal to treat my disability. How are condominiums supposed to address that? Now, it can be difficult, right? Often emotions are high, people are butting heads. It's a tough situation. So condominiums are required to accommodate that disability, but that accommodation is not an all or nothing matter. It's not you provide the accommodation or you don't provide the accommodation. The Human Rights Code provides a spectrum of ranges on how you can accommodate somebody's disability, and the Human Rights Code stresses that each case is a very individualized process. So you have to work with the person requesting that accommodation to find out what exactly the needs are and how best to accommodate them. So the code provides that medical needs are required to be accommodated, not individual preferences. So what we typically recommend in situations like that is to treat it with confidentiality and respect, but when you get a request like that, you are permitted to request medical documentation that establishes the existence of a disability. So what could that be? That could be a letter from a doctor, that could be a letter from a psychologist, or a psychiatrist or another medical professional that says, yes, this person has a disability under the code and is required to be accommodated by a service animal. So in a situation like that, if you get documentation like that, then accommodation may be appropriate. If somebody won't participate in that process, there is sort of a spectrum of participation. Everyone, including the person requesting it, is required to engage in a process. And that a process is a discussion between the condo and the person requesting the accommodation to come up with that. So it can be very individualized. I know we do have some time constraints, so I'm not going to go into all of the issues. That accommodation is not absolute. Condos are required to accommodate up to a point of undue hardship. Now, what is undue hardship? Now, that's sort of flushed out in the case law, but generally it takes into consideration things like costs and the health and safety of others. So using that same dog scenario, for example, someone could have a disability that requires a service dog, but the condominium must take the health and safety of others into consideration. So if that dog is attacking somebody, for example, and poses a significant threat to the health and safety of others, accommodation may not be appropriate in that situation. And a good case from the Condominium Authority Tribunal came out recently, that's TAMO versus Metro Toronto 744. Interesting case in that there was sort of a competing rights scenario. So one unit owner participated with the condo, needed a service animal to accommodate a mental illness, provided the appropriate medical documentation, worked with the condo, came up with a plan. The condo allowed that service animal despite a prohibition on animals in the condo's governing documents. Another unit owner claimed that accommodation shouldn't have happened, and that the other owner, TAMO in this case, the named owner in the application, claimed that she had allergies to a dog, and therefore the condo should not have accommodated because she was not being accommodated. The difference in that situation is TAMO didn't participate in that process. The condo had asked for medical documentation supporting that, asked to work in a collaborative fashion, and wasn't met with cooperation in that case. And the CAT here sided with the condo and found that it was appropriate to provide accommodation in that category for the individual who had participated and not for the other one. That's the Human Rights Code. The Human Rights Code supersedes all other obligations or all other legislation in the province. But that's not the end of the matter. Everybody knows their obligations under the Condominium Act, right? Yeah. Right? Two important sections of the Condominium Act are engaged when we're dealing with this kind of thing. One is Section 17, which is the board's obligation to take all reasonable steps to ensure that the owners comply with the Act, the declaration, the bylaws, and the rules. The second section is Section 117, sub 1. And what that section does is prohibits dangerous activities from being conducted on the condominium property. And so, back a couple of years ago, dangerous activities was, cut and dry. Someone's starting a fire. Someone is being violent on the common elements. Well, over the past couple of years, the courts have expanded that definition. How many people receive harassing, intimidating, and threatening emails on a daily basis from somebody? Right? Well, I'm surprised it's not 100%. Actually, I'm thankful that it's not 100%, but there were a few hands out there. the courts have expanded the definition of dangerous activities to include sort of verbal behavior, harassing, intimidating, threatening conduct. So if you're getting death threats by email, it might not even have to be that bad. It could be 100 emails in a day, 3, 4, 5 emails in an hour, all from the same person, all containing unreasonable demands. That is now considered a dangerous activity and captured within that prohibition. Now, this section is where mental health and condo obligations often clash. Because if you're receiving those kind of communications or that kind of behavior, it may be such that there's a mental illness behind that behavior. And there's a couple of cases that have come out recently that deal specifically with this. So I'm just going to go through 2 of them, although I have 3 up there for time issues. One is the Watson case. Now, the Watson case had an issue where the condominium was seeking the removal of this individual from a condominium. That is an extreme remedy. The courts are very reluctant to remove somebody from their property without there being extreme circumstances. But what was happening in this case is that the owners were sending complaints to the property manager that this individual was confronting people in the common elements, often in a violent or almost violent way, sending harassing and intimidating correspondence to the property manager on a daily basis, and then was actually convicted of arson by negligence for starting a fire in that condo. And so the condo brought an application under the Condo Act to seek this person's removal. Now, there was some evidence that came out during that court process that this individual was the subject of potential mental health issues. But that didn't excuse the owner in this situation from that conduct. And that's where we have to balance sort of the bad behavior and the mental health issues. The occupant in this case was removed from the condo for those purposes. Another case, Toronto versus Patatali, had a very similar circumstances. The unit owner had mental health issues. This one also involved a potential fire in the condo caused by this individual. But the mental health issues were flushed out in the court process. This individual was able to provide medical evidence that, yes, the bad behavior was due to a mental health illness. He was seeking treatment for that mental health illness, and his doctors said that while that individual was on medication and seeking treatment, he did not represent a danger to the other unit owners in the condominium, and so his removal was not granted in that case. So some very important things to consider when we're dealing with this, and we're going to flesh it out a little bit more in our discussions, but there is a confrontation often between strict condo enforcement of your declaration bylaws and rules and what may be a mental health issue. So key takeaways from some of these cases are, maybe before we get involved, before we jump to court, before you call me and we need to seek the removal of an individual owner, let's ask some questions first. Sir or ma'am, are you experiencing mental health problems? I know Iman's going to be able to discuss a little bit more about what some of those questions you can ask are and how we can deal with that. But often, we can address these sort of the root of mental health issues at the initial stages before we have to get to an extreme remedy of seeking removal in the court. So just for a very brief overview, there is some other legislation in the province that deals with mental health and which impacts condos. First one is actually the Condominium Act. Under the qualifications to be a director, if you have been found, or if an individual has been found incapable of managing property by a court, that person actually cannot serve as a director on the condominiums board. Substitute Decisions Act, most people are aware of that act, but are usually aware of it as powers of attorney, right? Who has a power of attorney, or who is aware of somebody that has a power of attorney for property? Probably most people, right? So one thing to consider is if somebody is having a mental health crisis at the condo and you're a property manager or a board member is being asked to deal with that, is there somebody, a family member, example, or somebody other than the individual owner who's experiencing the crisis that you can discuss? And you can often request a copy of a power of attorney document saying that you can discuss it with one of their family members, and that family member or a close friend of that individual has that legal authority to deal with that person's property and can assist you in dealing with some of those challenges. In very extreme circumstances, Legally, a condo is actually entitled to apply for an assessment of an individual under the Substitute Decisions Act. But that's probably a very last resort. Can be a very expensive process, but that is something that is there to help deal with it. Last piece of legislation I want to mention, just as, again, a general overview, very top level, Mental Health Act. Mental Health Act really concerns the authority, so the police or doctors, and that piece of legislation allows those individuals or those organizations to potentially have an individual assessed and or held in a facility for a certain amount of time to have that individual assessed to potentially deal with some of those problems. So again, emergency situations, and if the police have to be involved, that's probably where the authority they're getting from to address those situations. Sir?
Chris, you talked about removal. Is that an owner, or you can remove an owner as opposed to a tenant?
Yes, so the Condominium Act, again, Section 117, is that dangerous activities provision. And so individuals, if they're causing potential damage to the property or potential injury to another individual, a condominium is entitled to apply to a court under Section 134, which is a broad remedy that the court has to grant relief that is just in the circumstances. It's very rare that a court will order the removal of an owner or an occupant on first instance, which means the first time you go to court to get an order to curtail that. But it is a remedy available to the court and was addressed in those 3 cases. So typical scenario, again, this is very extreme circumstances. Individual is posing a risk or has already caused extensive damage to the property or injury to an individual. Condo can apply to the court. Court will often order that behavior to cease. And if there's a breach of that order, the court can order the removal of the individual and the sale of the unit from that individual. Again, extreme example, but is available in the most extreme circumstances. Thank you. That's sort of the broad, overarching legislative framework for dealing with these kind of things. And now, as Bill said, we're going to get into the practical solutions to some of these issues. So thanks.
Thanks, Chris. So we're going to get into some scenarios now, and one in particular that I know everybody's anxious to hear about. So let's do a couple of kind of smaller scenarios, and then we'll get into the large one that occurred in Vaughan. Okay? So Mr. Jones has received a notice of lien, and he enters into the on-site management office. How many of us have been in that position? And starts screaming at the administrator. Becky is the administrator's name, by the way. And Mr. Jones is demanding action, says that he is the son of the elderly unit owner that doesn't understand the mail and the notices that they're receiving. He's yelling, he's swearing at Becky, and he says he's not going to leave until this is fixed. So what can Becky do? What can the board do to prevent this? And is this bad behavior or mental health? Let's start with Bill.
I would say that this is a good example of bad behavior that happens on a regular basis. I think a lot of parents are elderly, living in condos now, and their children are looking after their well-being and their affairs, and they get a little passionate about it. But just the scenario itself brings me to a whole bunch of thoughts that I think we should try and hash out as we go through this. The Occupational Health and Safety Act says that you have to have a safety plan in case you're feeling in danger in the management office. And most management offices are afterthoughts. They're in the basement, they're in the corner, there's no windows, one entrance, one exit, no way of possible escape plan. I think that's a bad scenario because you don't know how far that person's going to go, whether it's bad behavior or mental health. So I think there's a whole bunch of other things that we have to think of as an industry in preventative before that even happens. And our obligations under the Occupational Health and Safety Act would say we should be doing that. And every board should ensure that there is a safety plan for their employees and contractors on site.
Okay, Iman.
I just wanted to start actually just by asking a question before I get into answering the scenario. Just kind of giving some advice on that. What percentage of the population do you folks think have mental health? 100%. But I want to just present this question in a way so that we can all center ourselves around understanding what is mental health and what is mental illness. So all of us have mental health. We all have a mind. We have a brain. We have mental health. We have a body. this is physical health. And that's how it's been offered to us, right? For me too. Before I started working in the mental health industry, I did not understand that question. Because to me, mental health equals mental illness. So just an offering to kind of switch our, thinking process, or try to kind of look at it like everyone has mental health. Mental illness is a diagnosed illness, whereas mental health is your overall well-being. So when we talk about bad behavior, I don't think there's any I can't differentiate between that as an educator and what I know about mental health and mental illness. Everything is based around mental health. So this person was having, not a good mental health day, right? And we've all been there, have we not? Maybe we're not going to lash out at, a property manager or going to an office, but maybe we have been in a situation like that too, right? So I just wanted to center it around, just an offering to just first kind of like, okay, we all have mental health, we all have bad days. Sometimes folks are under so much more. I know I'm taking care of an elderly mom as well right now, and it's really frustrating at times what she's experiencing in her condo for me to hear. But that being said, going in and lashing out on someone is not something that any of us should ever have to sit and face, right? So the Safety Act comes into play. So for us, for example, in the mental health workplaces, we have what you call a code white. If someone comes in and they're having a bad mental health day and it gets escalated and our safety is a concern at that point, we call a code white. There's another entrance that a safety plan, just like Bill pointed out, that all needs to be in place. So for me, my advice would first be, if anybody was asking me this question, like, hey, what do we do? I'd say, well, what's your safety plan, for the people that work for you? Because that's first and foremost. Your safety is first and foremost, right? Taking care of others, just like the airplane, right? Put your mask on first before you take care of others. So we want to take care of ourselves first. So first and foremost, a safety plan. Of course, understanding that we all have mental health and we all have bad days. Understanding how can I approach this person in a way that I can have a conversation with them to see that, in a kind and compassionate way. But of course it's hard, right? In situations like that when, fear kicks in and, your flight or fight kicks in. It's very hard. So I want to acknowledge all of this is hard. These are offerings to say these are the steps we can take, but in the situation, it's got to be, in terms of your own safety first, and then approaching it in a way that is you're able to have that conversation with that person. I think I kind of just want to leave it there.
Okay.
Yeah.
Thank you. Chris?
This is not an uncommon situation. How many people get calls every day about arguing about a missed common element fee payment?
Oh, yeah.
I think differentiating bad behavior from mental health issue requires us to sort of take a step back. And because often the symptoms of a mental health problem, and I'm not a doctor, but they present themselves or have the potential to present themselves as bad behavior. So this gentleman who's come in to yell at you for leaning their unit, is this something that happens every month? Is this something that happens, is this a one-off? Is that yelling or is that situation something that doesn't make logical sense? Is it connected with the lien? It's not uncommon that someone just gets angry because they've missed their payments and now you have a lien against that person's unit, right?
It was the son, though. So
it's the
son of an elderly person who's
Right.
not understanding the documentation.
So you take a step back, that elderly person, whether or not they're elderly or not is probably not particularly relevant, but is that person suffering from, maybe they can't understand the mail, maybe they prefer to get, the notices sent to the son instead of to the unit. So can we avoid that situation in the future? Maybe we can ask that person, the son who's come in, well, do you have a power of attorney to handle your mother's finances? And if they do, well, okay, great. Well, give us a copy of that. We'll send the notice. If that's not the case, maybe this person is just being angry, and we have to, consider the health and safety of the property managers as well. The Occupational Health and Safety Act does entitle workers to a safe and harassment-free work environment. So we should take steps to deal with that as well. So I think there's some questions we can ask at the beginning. Do you have a power of attorney to deal with this unit owner's property, and we can work with you to establish a process for that. Or if it's just bad behavior and that's not a situation, we also have the remedies under the Occupational Health and Safety Act or the Condo Act to deal with that as well.
Bill?
I want to offer one tip and trick. You all have one sitting in front of you. If someone comes in and they're yelling and screaming and at the top of their lungs, one of the best things you can do is offer them a drink. If they take a glass of water or sip from a cup of coffee, they have to actually stop and drink. And once they do that, it calms them down a little bit. And while they're drinking that water or calming down, they'll sit down and they'll start again. So it's a quick trick. Have a bottle of water around just in case someone comes in, and it calms most people down right away.
There's also probably some de-escalation messages that Iman can, of course, talk more about. That may be more appropriate than calling Chris and getting legal involved right off the bat.
Yeah, for sure. And I love what Bill are you sure you're not the mental health expert? He's doing really well. I would say definitely, checking yourself in terms of where you're at in that situation. Like I mentioned before, we immediately go into flight or fight when someone attacks us, right? This is our natural response. So rather than being reactive, my offering is always to be like preventative in some way, right? So having these scenarios hashed out with your team, right, with your managers, and speaking about them to an extent where you can actually have the steps that you can follow before it actually happens. So, having conversations like, yes, what can I do to make this person feel seen and heard? Because really, everyone wants to be seen and heard. And usually that's at the core of these situations. They just want to be seen and heard, right? Something's happening. They don't know, maybe they don't have a lot of support in their own system. And that's not for you to figure out. But as a human being, with your own mental health and knowing that we all have situations that we're all dealing with, just having that offering, would you like to sit down, glass of water, please tell me, listening in a kind and compassionate way, compassionate listening, like you're looking at them in their eyes, you're actually paying attention. It can really do wonders in a person's, in that de-escalation process. Yeah.
Great. Thank you. Next scenario. Mrs. Garcia is a unit owner and has been submitted complaints. Okay, I should have vetted this first. Have been submitting complaints to the condo manager and board about being harassed by a neighboring unit owner, Mr. Green. Now, Mr. Green frequently bangs on Mrs. Garcia's door, and when she answers, he's agitated and demanding that she stop spying on him and leaves notes on her unit door and her car. Mr. Green claims that Mrs. Garcia's using secret listening devices and cameras to record him and plays music loops and audio tones all night intended to affect Mr. Green. Now, none of this is true, as Mrs. Garcia doesn't interact with Mr. Jones at all. So how can the board respond to Mrs. Garcia's complaints about Mr. Green's activities? And mental health, bad behavior. We'll start with Iman.
I just want to, I have a loved one that has a mental illness, so just being a little kind and compassionate when we're talking about these scenarios would be really, really nice. It's not a laughing matter in my life. It's actually very serious in a lot of our lives. So just starting it off with that offering to be kind and compassionate when we're talking about these scenarios. Definitely sounds like the person could be experiencing mental illness, but this is not for us to diagnose. We're not doctors. So in terms of the complaints, I'd say, again, the person's safety is first and foremost. So the person that's having the person come to their door, I would say they need some sort of a plan with the property managers to take the situation seriously, because it's a concern for her safety. So regardless of this is us not oh, this is mental illness, let's just deal with it like it is. I'm not sure if there's even a plan for that, but there should be, again, kindness and compassion around dealing with such a person. And so going back to taking the complaint very seriously, having some sort of a conversation with the person that has been coming to the person's door. So I know I had a situation in my condo where a friend of mine in the condo was having a similar sort of a situation, and so they sent some emails, they were logging the emails, and then they sent an email to the person that was going to the person's door, so just making, but again, like in a way that's like not attacking the person, because we can tell that they're obviously experiencing something.
Right.
And, mental illness doesn't discriminate age, gender, culture. Anybody at any time can experience mental illness that severe, what we just talked about in the scenario. So, we're all going to get older as well, right? And there's going to be different things that we're going to experience. Illness comes at any time. So, yeah, I would say first and foremost the safety, having conversations with property managers.
Okay, thanks. Bill, how would a board member handle that? Or how could a board member handle that?
Well, the board is always strapped with the duty to maintain the safety of the persons on the property. So if there's any belief that there's a danger, and if he's coming down to the unit or up to the unit, or up to the unit, is the scenario, knocking on the door, agitated, I think it's reasonable to go to the next step and say that there's a danger to that person. So the corporation would have a positive obligation to at least intervene. So you probably instruct the property manager, if you have a property manager, to have a conversation and follow it up with a report. I call that a slow start. Just address the issue, indicate to the person who's knocking on the other person's door that they should not knock on the door. If there's any issues, please bring them through the management office, redirect their anger or their attention back to the management office, and then paper your file, because if there's obvious paranoia, possibly, maybe Mrs. Smith is a spy. We don't know. So based on the fact that you have no idea what the actual truth is, just start papering the file until you get to the point where the proof shows itself in the repetitive nature.
Mm-hmm. Chris, from a legal point of view.
From a legal point of view, I'd like to first echo Iman's comments that I think when we're faced with these kind of things quite often in the condominium world, and we have to start off with a compassionate stance. So this individual is clearly having, to take the scenario, is clearly having a mental health crisis. Now, can we take some steps to see if there's somebody in their family or a close friend who can assist that individual in dealing with this? Now, that may not be the case, and as Bill mentioned, there are obligations on a condominium to ensure the safety of other people. And there is going to come times where mental health issues may represent a danger to other individuals. And that's not a failure of you being, or of a property manager not being compassionate enough. It's not a failure of having, an inappropriate policy put in place with these things. These situations are going to arise where you have to take the steps available to you as a condominium corporation to deal with these under the Condominium Act. First and foremost, I think if you have any reason to believe that somebody is in imminent physical danger, call the authorities. Either call the mental health crisis line or call the police. Okay, as a board member or as a property manager, as a lawyer, I don't want you tackling that person to the ground to save somebody. I don't want you putting yourself into a situation where your physical safety is also at risk. As Iman said, you got to put your own mask on first before you can help other people. I think this situation, is, to give another example, hoarding, or for lack of a better word, hoarding is a problem that occurs in condominiums and is often attributed to a mental health issue. Now, there are potentially accommodations available for an individual who's suffering from those mental health issues. But, as the engineer, if there are any engineers here in the audience, they'll tell you sometimes that hoarding poses a structural danger to the condominium corporation. And so you have to balance that issue. It's how do we handle this mental health issue of hoarding with the imminent structural collapse of the floor onto somebody's unit below, right? Those are balancing acts you have to do. I think the imminent structural collapse and potential life-threatening condition to somebody else will lead you to take those steps available. We've got to apply to court for an immediate order in that situation and deal with the mental health crisis after that. And first and foremost, secure your personal safety and the safety of others, whether that's calling the police or calling me to go to court. or if it's dealing with something that can be accommodated with, perhaps a crisis management line or some other assistance.
Iman, what are some of the resources that a board of directors could use or a property manager could use in our local area?
Yeah, so we're in Kitchener.
We're in Kitchener, Waterloo, well,
Sorry.
Cambridge, Brantford.
A little all over the place.
That's
Yeah,
okay.
I think I drove through. Yes, so Kitchener, Waterloo, Cambridge, Guelph all have a CMHA branch, and all of our branches have a mobile crisis team. Have folks heard of the mobile crisis team before? Just show of hands, I'm just curious. Yeah. Okay, not many. So your mobile crisis team, you can just Google CMHA in your region. If you're in Guelph, Waterloo, Kitchener, they work very closely with the police. So again, going back to first and foremost, if it's imminent safety concern, call 911. We are not trying to make anybody navigate a mental health crisis here in terms of, you gotta go, it's way too complex. And you folks are doing work, and you need to keep yourself safe. So I just always want to go back to that. If you are in imminent danger, please call 911. We actually do the same in mental health at CMHA as well. If we're in imminent danger, we call 911. We have a mobile crisis team in our office. We call 911, right? So that's your first and foremost. If there's been some sort of communication where family members have been involved, I know a friend of mine, her situation was such where a family member was involved, and you're able to, maybe you have their number, you've exchanged, hey, if this happens again, can I just call you, right? I know I have that with my loved one. So you can access that, and then you can also then access the mobile crisis team. Their hours are 7 days a week. I believe it's from 8 a.m. to 12 a.m., 8 a.m. to 12 a.m. They're available, so you can call them, and they are there on site right away to help de-escalate. The team consists of a social worker, mental health nurses, and a crisis worker as well, I believe. You can, again, Google your crisis line as well. What do you do after you've experienced something like this, and you have to now go home, and maybe you don't have anybody to debrief with, right? You're I don't want to call my family and talk to them about this. This was just so intense for me. There, I would offer to you as well, if you don't have, a therapist or, someone you can talk to about this, to call the 24-hour crisis line. It's called Here 24/7. I have some cards. I can offer that as well to you. You can even offer that to the people that are coming into your space. It's just another resource that I like to offer. You don't have to be in immediate crisis to call the crisis line. You can just be having a really shit day, this, someone coming in, attacking you, having something really tough to deal with for you. Again, I take it back to your safety, right? You can call them and speak to them about it. They're all mental health trained professionals calling line. Yeah, imminent danger, 911, mobile crisis team if you can, help de-escalate the situation with family. 24-hour crisis line for yourself as well as the person that's there.
Great, thank you.
So the way it's posed, if it was an initial complaint of harassment, I appreciate that if it's gotten to the extent where you're not calling in for that type of help, yes, I understand, and we have to go legal. But this is an initial complaint, and as managers, aren't we supposed to act as an unbiased party to treat all homeowners in the same respect for whatever their complaint may be? So what would be the steps to move forward with just initial harassment complaints so that we're not overstepping or causing any undue mental health?
Good question.
Great.
That's a great question. So basically, just to reiterate, what are the steps you would do to address something like this upon initial complaint? So again, Condominium Act, Section 17.3 requires a board to take all reasonable steps to ensure the compliance of the unit owners and the occupants of the condo. And again, harassing, intimidating, threatening conduct, contrary to 117. So if you get an initial complaint like this, I think the first thing is to do is, again, you're right, you are a neutral third party at the outset, and is to ask questions. So the first thing to do, I would, send a letter to the individual involved. We received complaints that this is happening, kindly stop doing that. That is usually the first step in such a case like this, if the issue is not obvious at the beginning. So if you're getting complaints about if the initial complaint is somebody is spying on me and they have cameras going through the ceiling to watch me. That I think is kind of a triggering phrase. It's, again, to pose Bill, it might be true, but chances are it's not. I would look into it first, maybe make entry to the unit just to confirm that he's not actually, or that individual is not actually factual. And then if it escalates from there, then you can either reach out to a family member if you do know one. Often you won't know one. If the behavior escalates and becomes dangerous, or you could reach out to counsel or call the mental health crisis line.
But I think it's the opposite way. Sorry, if I can interject. I think the question is the opposite way. So this person is complaining because this gentleman keeps knocking on her door and telling her to stop harassing him. So now she's getting harassed. So as a property manager, you have to treat both the same way.
Right. So that's where you've received complaints that somebody is being harassed. That engages your obligations under the Condo Act to deal with that. So that's where your reasonable steps kick in. You send a letter to the potentially violating individual to cease that behavior. If that behavior doesn't cease and or escalates, then you go through those other steps. So sending that initial letter is probably in 99% of the cases the appropriate first step.
And what about the board of directors, Bill? At that point, you've only seen complaints of harassment on both ends. You haven't seen all of the other parts of the scenario.
I think it's been made pretty clear to us from CAT decisions that they really want us to have a true in-depth investigation before that first letter is sent. So the property manager probably has to go up to that gentleman's unit and discuss the incident and get the other side of it.
Really?
See, I disagree.
I know exactly where this is going. Everybody water, everybody water. Okay. So that's
One
so
way
you
or
heard
another, you
the
have to
objection.
investigate the situation. Whether you do it from the safety of your office or feel comfortable going up to the unit to discuss face-to-face, you then document what you found at that point. And then after your initial investigation, you find that there is merit in sending a letter to start papering the file for enforcement, then you do that. If you find that there's clear and obvious mental health, then maybe your issues, then maybe your approach is slightly different and you call for some crisis help.
You can also, getting both sides is so important and treating both with dignity and respect, but first and foremost making sure that the woman is not being harassed on a daily basis like that. That's first and foremost. But going back to the mobile crisis team, also just going back to I'm thinking of the scenario that's kind of similar to this. A friend that my friend of mine was dealing with, she had like the concierge go out and speak to the person as opposed to the property manager who was female. So that's an option. I don't know. I just want to put that out there. But also the mobile crisis team, like you can actually call them and say, as a property manager, like, I am concerned, this is the situation, could you go do a wellness check? So they're called wellness checks. So you can do that for a loved one, you can do that for someone that is experiencing, they are thinking that there's something being recorded in their home, so you're concerned for their mental health. So you can send the mobile crisis team as a property manager to do a wellness check on this person as well.
And I think there's just opposition right now because so many people are elevated due to the pandemic that we've been experienced with situations being in buildings where we no longer want to confront owners. So I think that's where the opposition lies. It's not necessarily.
If I could just jump in I think this is, I think an important takeaway from this is we are all going to interact with and experience mental health issues on a wide spectrum of incidences, whether it's on one end, an individual requesting a service animal to treat a mental health illness, and whether or not accommodation is going to be provided on one end, all the way to potentially dangerous situations involving violence on the other extreme end of the spectrum. I wish I could create sort of a flow chart as I would in other areas of condominium law. It's like, okay, how do we register a Section 98 agreement? We do this, we do this, we do that. Unfortunately, or fortunately, depending on each human is individual, and the Human Rights Code sort of tempers the harsh reality of the Condominium Act enforcement with making everything sort of an individualized process. So I think the important thing is asking questions at the outset of things rather than jumping to enforcement, or rather jumping to calling the crisis team. You may not have to do that. I think the important takeaway is awareness, and that you're not alone on this issue. No property manager and no board member has to tackle all of these issues on their own and in isolation. You have the resources, and they're there. They're just, they may not be well known. You have your lawyers, you have your mental health issues, you have your experienced board members, and that they're there to ask you. So don't be afraid to ask questions and sort of get to the bottom of these things before jumping to enforcement or to some other option. There may be information available that people are willing to give you to help you sort that out at the beginning.
Thank you. Okay, we're going to get into the scenario now regarding Valeria. Everybody's familiar with this case. It was certainly all over the news, and certainly it was such a devastating case in Vaughan. So I'm going to give you the scenario on the basis that I am the person that was there. I'm clearly not the person that was there, but I am telling that I'm going to give you the scenario based on that, because the scenario came into us from somebody that was a part of it. Does that make sense? Okay. It's a long one, so I'd ask for your patience on this, okay? I moved into Valeria in July of 2017 with my wife and daughter. Our parking space is directly adjacent to another resident owned the 2 spaces directly in front of and attached to ours. Over time, I ran into the resident, and after a while, he started to tell me about a noise in his unit that the condo didn't do anything about, and the noise had been there since the condo was built. He was the first and only owner of the unit and gone after the builder to fix it, but had not been able to get the builder to do anything about it. He then complained to the board and had not had any success in getting them to fix the problem. After a few conversations, giving him some possible solutions to getting the noise looked after, he asked me to come to his unit to hear the noise. I reluctantly agreed, although I did not want to be part of the complaint or the board in this condo where I lived. I told him that I would come by next week one night when I got home early and had no evening meetings. He came up to my unit every day and knocked on my door asking my wife to remind me to come to his unit when I got home. I finally got home one night before 7 o'clock and stopped at his unit on the way to listen to the noise. I knocked on the door, and he was obviously under the influence of alcohol, as he was slurring his words, talking loudly, and offering me a cognac or a glass of wine to join him. I turned down the offer and walked through his unit with him, listening intently for the noise. I heard nothing. He told me that the noise was happening right now and never stopped, and questioned why I couldn't hear it. I offered that my hearing may be suspect in the range that the noise was in, so I suggested that he hire an acoustic engineer to check all sound ranges and determine the frequency and level of the noise. He blew up. He was not going to spend one penny proving the sound that he could clearly hear. I left his unit, and he became rude and aggressive. I suspected that he may have aggression issues, but also I empathized with his situation. Later that week, I had the occasion to speak to a condo familiar lawyer, and I asked if they would be so kind as to give him 20 minutes of their time to discuss his issue and potentially get some legal solutions. The lawyer agreed, but told me to make it clear to the unit owner that at any time beyond the 20 minutes would be charged at their regular rates. I went back to the unit owner's unit and explained the offer and gave him the business card for the lawyer. I came down to my car one morning, and my mirror was broken. The parts were not anywhere to be found. I went to security to see if they had a camera on my car, and of course they did not. I got the mirror fixed. A week after that, there was a long scratch down the side of my car. Again, no video recording. Then my car started to have spit on it, virtually every day. Then I got a note on my car telling me that I owed the unit owner $3,076 for his legal bill, and that I was part of the conspiracy to take his money. The note was written in a very angry manner with broken thoughts and unrelated sentences following each other. It was then highlighted in random scribbling manner with a yellow highlighter. I also became aware from another unit owner that my picture, together with my wife and daughter, were posted on the complaining unit owner's Facebook page, telling everyone that I had lied to him and that I was part of the conspiracy to torture him and take away his money. At that point, I decided to distance myself from this unit owner, and I submitted a complaint to the condominium about the vandalism to my car, the harassment, and I provided them with a copy of the note left on my car. That was April of 2018. The board adjusted a camera to cover my parking spaces, and the vandalism stopped. For the next 3 years, I witnessed this unit owner picketing in the lobby with a sign saying that the board was trying to kill him. He would stop every owner, visitor, delivery person, and the staff member if they even made contact with him. Then one day, he stopped picketing in the lobby and started picketing in front of the building. I presume the condo had obtained a court order to cease the lobby actions. Then about a month later, he started picketing at the local mall. I presume the order was extended to anywhere on the property. The harassment continued and escalated to the point that I asked my family to stop talking with him and to try not to even make contact with him, as his volatility was clearly escalating. I started retrieving the mail from the mailroom, which he lived beside, by myself, and asked my family not to go to the ground floor, as he was always there. This went on for years, and my family finally decided to speed up our move to cottage country, which we had planned to do in 2022 when I retired. So in July of 2021, we moved out of the property. On moving day, one of the board members and his wife approached me in the underground and told me that they were afraid for their safety because of this individual and asked for my candid advice on what they should do. I told them that if they were feeling unsafe and the condo was doing everything they could to stop it, then maybe they should resign from the board and put some distance between them and him. The board member did not stand for election and was replaced when his term ended in May of 2022. On December 19th, 2022, the condo, having exhausted all enforcement rights, was scheduled to present a motion to request the forced sale and removal of the unit owner from the property. They never presented the motion, as the unit owner went to 4 board members' homes and shot and killed 3 board members, 2 board members' spouses, and seriously injured the 3rd board member's spouse. He was killed by the police in the building when they responded to the call. The board member who had resigned and his wife were among those killed, even though they were no longer associated with the board. After the incident, the family of the shooter put out a press release indicating that their father was abusive, aggressive, and unpredictable, and they had to distance themselves from him for their own safety. Whew. I don't even know where to start with that. Iman, please.
I would just like to take a moment of silence for the lives that were lost. That was really heavy. So if you could just have that for a minute. I will let the lawyer.
That's called kicking the can down the road. Chris.
I think this case touched everybody in the condominium community, not just here in Ontario, but everywhere. Absolute tragedy. And if we could predict these kind of things wouldn't happen, but we can't predict. You know, sometimes, and nobody wants to hear this from a lawyer, but sometimes the law is just not equipped to deal with every single situation. Based on that scenario, do I think the condominium was taking the appropriate steps, seeking the removal of this individual from the condo? With the tools available to a condominium corporation from a legal perspective? Probably yes. Was this person experiencing not just a mental health crisis, but ongoing series of mental health crises in a prolonged this individual, and I'm not a doctor, is experiencing a mental health illness that's not limited to a crisis. I don't know if the condo board in this situation had called the police on multiple occasions. I don't know if they had reached out to the children of the owner. I don't know if they had called the mental health crises. Is that something that could have been done that would have avoided this? I wish I could say that I would, if we follow step 1, step 2, step 3, these situations won't happen. I wish I could say that, but I can't say that with any sort of certainty. What I can say is that these resources are available. Can we utilize these resources? Yes, we can. Would it have helped? God, I hope so. But those tools are there to, from the de-escalation to the extreme removal orders. I wish we could, they are there and they are available. Can we stop all violent crime? I think we've been trying to deal with that since 2 people started living together, right? But, in close proximity. I think we've got to be very careful. Again, if your health and safety, if there's any indication that your health and safety is at risk, call 911 immediately. That's all really. Can we take the steps available under the Condominium Act to seek the removal? Yes, we can, and that condo was doing that in this situation. But condos are not the police. They are, property managers are not necessarily SWAT teams or de-escalation professionals. So when you're presented with these kinds of situations, you have to call the relevant authorities. That's the only thing I could say. Is call 911 as soon as these issues present themselves.
Bill?
I feel sorry for everybody in this situation, including the shooter. The Condo Act puts a positive obligation on board members under Section 17 to do something about that. Under Section 117, they don't have the right to go to court and ask for an assessment, competency assessment, or any other type of mental wellness check. So there's not a lot of tools available to deal with that for boards. That's why this seminar should be an eye-opener and help the whole industry to start thinking outside of the Condo Act. Because the Condo Act has no solutions. It needs to have a solution, but it has none. Also imagine yourself as that poor owner, which you don't know that there was mental illness or not, because no assessment ever happened, but thinking or actually having a noise for 20 years that they lived there with nobody listening to them and getting pushed harder and harder into the corner. And each time they went to court, the awards were higher and higher against the unit owner. So if you put yourself in that person's position, you have to say, well, they were backing him into a corner. There was no other option in the act other than backing him into a corner, because you have to escalate, because you can't go for the final order before you take all the other steps to escalate and show that the behavior is continuing. So, in my opinion, the act failed this situation, and board members have a positive obligation to look after the safety of the other owners, which in this case put themselves at risk. That shouldn't be. They're volunteers.
So do you suggest we change the act?
I think Section 117 can include the right to request a competency or mental wellness assessment. The police have the right to do it. I guess what's unique about this situation, there were no specific incidents that would say you should have called the police at that point in time. It was a slow escalation of pressure and court battles back and forth, and the unit owner naming the board members directly and the condominium, and it was an escalation of tension. Those people met here every day.
So this situation here very much is close to our team. We've had more run-ins with this. Our condominium corporation in Kitchener-Waterloo is actually the first condominium corporation in Ontario that was successful in having a unit owner forced out by sale. And I will tell you that unit owner was very, very aggressive, threatening the staff, came to the office many times to the point, this is over 15 years ago. So this was a long, long time ago. Security cameras were very archaic. Taking this type of thing was not at all taken seriously by the police or anybody else. Because we tried to involve the police, we tried to involve court orders. It took over 8 years before we were finally successful. And do you know what made it successful? That gentleman took a bloody butcher's knife and galloped down the corridor to run after one of our residents, assaulted another, and did about $15,000 worth of damage to a car. And it was only when it was absolute aggression did the court take it seriously and say, we now have to shut this down, and now it gets to stay in the Wellington hotel. So this, and when someone says, does the property manager, if there's even a niggle of, I'm sorry, a mental health issue, crisis, we as property managers are not equipped for that. That's not our job. We should be doing what we do with every other expertise. We call the experts, and if it means calling the police, God bless, they have community service officers. Go see them. I'm not
No, this is what Iman is saying.
Yeah, you know what, but again, even, am I gonna be sending my staff to interview someone in their unit? Goodness,
No.
absolutely no way.
I don't think anybody's suggesting that. I think they're just suggesting to ask questions. Even Bill backed that up and said, if you're not comfortable going into a unit, you obviously don't. But
Please no.
Yeah,
but there is a
if I can
scientific
just-
that.
if I can just say something.
Hold on. Okay. Thanks, Michelle. Thank you. Okay, Chris, go.
Yeah, so I think very, very valid concerns.
sure.
I think safety is the number one concern. Somebody being backed into a legal corner is not an excuse for physical violence or murder. And your personal safety is
Always.
paramount. So again, I think that the core takeaway, at least from my perspective, is questions, followed by, is this a mental health issue that requires something under the Human Rights Code? Or is it an accommodation perhaps? Or is this a mental health crisis that requires the intervention of the relevant authorities? There are going to be circumstances, that's one of them, this case is another one, where the relevant authorities need to be involved. So don't feel like you can't call the police immediately if there's any indication that your physical safety is going to be at risk.
And I think I'd like to, if you don't mind, Michelle, address your situation, your question. The difficulty with the approach that we've traditionally taken to get rid of an owner is it takes so long. And during that time period, the situation escalates for everybody, and the danger goes higher and higher. And the point that I'm trying to make is that there should be a point in time when the corporation can have a pressure relief valve and say, let's find out whether this really aggressive person has mental illness that needs to be addressed, and get the court to force that to happen. Because maybe at that point, they get on the right pills and the whole thing disappears. The difficulty with the current approach is that unit owner had a forced sale of their unit, and guess what? They bought in my condo now. The problem hasn't gone away. You haven't addressed the root problem. And I know property managers are not social workers, we are not psychologists, we have no business in doing that. But at some point in time, even the courts recognize that this person has some issues with reality, and whatever that is, or aggression issues. And they should be given, if the judge had a section in the act that said, you could send this person for an assessment if you deem so. And the corporation could do a simple application to do that, as opposed to going through, $50,000 of legals to go through the Substitute Decisions Act. There should be a simple way to find out whether or not there's something else happening here. Just addressing the rules and saying thou must follow these rules is not accommodating. We have a duty to accommodate. As soon as we believe that there's a mental health issue, I think that duty passively steps up. It doesn't actively step up because it has to be a request for accommodation. But given that it's more prevalent in society now than it was before, I think the board should be given new tools. That's all I'm saying. If in Section 117 they gave the board the right to request a competency assessment or a mental illness assessment, then maybe we could have to de-escalate these things before it got to the point of backing into a corner.
Come on.
I would just like to offer just a moment of, when I read this scenario, I actually have to be honest, I didn't think we were going to read through all of it. So I'm going to say I apologize. I should have offered a trigger warning for everyone, because obviously emotions are very high and you're all experiencing. I'm very sorry for what you've been experiencing, and no need to apologize to me at all. I understand. There's emotions are high. And you're all dealing with very complex situations. That's why the conversation is always centered from my perspective as a mental health educator. I am not clinically trained. It's an education that I'm offering, that you are not psychologists. I'm not a psychologist. Even a psychologist would be calling 911 in a situation like you experienced. And absolutely, you should be given those tools. You should be given a safety plan. You should not have to face the person yourself. There should be someone in place to do that for you, like the mobile crisis team, or someone on your team that, maybe has gone out and had some mental health education and training, because those are free. And Some of them cost a lot of money, but there's a lot out there. So there's a lot that can be done to take those steps to get those tools in place so that you're not facing these situations from I'm alone and this is not what I'm supposed to be doing. And just like I mentioned before, like we as well, working in mental health, dealing with very complex situations, we also call 911 many times.
My personal opinion, the takeaway from all of this is that there's no clear-cut, follow-the-checklist answers when dealing with these kind of challenges. I know when I attended the live session, I wanted answers. I wanted definite. Here's what you need to do. Answers on how to handle difficult clients. But the reality is it's just not that simple. All you have is the tools around you. Utilize the resources, whether that's documents, legislation, policies, procedures, or people. Property managers, contractors, superintendents, engineers, lawyers, emergency response personnel, or mental illness experts. And don't forget, in all of this, take care of you. My name is Michelle Dyer, and thanks for listening to this episode of the Canadian Condominium Institute, aka CCI podcast, presented by the Grand River Chapter. Tell your friends this podcast, as all of our podcasts, are available across all major podcast platforms, including Buzzsprout, Spotify, Apple Music, and YouTube at CCI Grand River Chapter. Until next time.